This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to welcome two distinguished panelists, both former guests to the show, Dr. Marom Bikson and George Reis. Now, Professor Bikson is a professor at the City College of New York, where he is the co-director of the Neural Engineering Group. He specializes in the effects of electricity on the human body, and his research has been published in numerous scientific journals. Additionally, Professor Bikson has been awarded multiple patents and holds a Ph.D. in Biomedical Engineering from Case Western Reserve University, my own alma mater. Professor Bikson, welcome back.
Thanks for having me back.
And Mr. Reis is the owner of Imaging Forensics, which provides forensic analysis for a wide range of media, including video, digital images, photographs. He's a sought-after expert witness in the U.S. and abroad, and is a published author. Mr. Reis, welcome back.
Thanks, Noah. It's great to be here.
For today's panel, I'd like to focus on the expert-attorney relationship. Let's talk about first getting off on the right foot with the attorney. Mr. Reis, how do you get started with a new attorney?
Well, in that initial call, I, of course, have a list of questions that I want to ask the attorney to find out about the case, who's involved, if I have any conflicts, what kind of evidence that they have, and if I'm a suitable fit for that particular case. But during that conversation, when I'm asking the attorney questions and they're asking me questions, I also like to see if there's a relationship that can be built there, that we seem to have a similar approach to the case, and that he respects or she respects my expertise, and I obviously respect their approach to the case and the way that they are presenting themselves.
Professor Bikson, same question.
I really like the way George framed it as a sort of a relationship. I think that every individual you're interacting with professionally, every lawyer may have a different approach, a different attitude. And so I think as part of those initial interactions, they're gauging, how they work with you. And I try to be very sensitive to the fact that, different lawyers can come in with very different styles. And I try to be amenable to that while also making it clear that, this is what they're getting as far as interactions with me.
When you say different styles, can you go through a couple possible different styles that you've run into in your expert witnessing experience?
Sure. I mean, I think, especially initially, I think the lawyers are very sensitive to assessing how well you might serve, under, let's say, deposition or facing an antagonistic opposing counsel. So I do find in some cases they might push you a little bit initially, right? They might challenge you on certain points. But I also realize they're doing that in sort of like a friendly fire kind of way, right? They're not testing you here. They're trying to identify things like, okay, well, you have a lot of expertise in domain A, but this is an A1. So how would you respond to the fact that you may have a deficiency in A1? And I think they're listening as much to what you say as how you are able to sort of calmly respond and address what might sound like a challenge.
Does that square with your experience, Mr. Reis?
Yes, I think so. And it's interesting, though, when they do ask those questions in somewhat of a maybe aggressive manner or assertive manner, it could be easy to take that wrong. And I think we need to remember we're developing a relationship, and I would say they're testing us in a way. They're wanting to see how we respond, and that's important for them to understand. So we need to realize during that conversation that it could be easy to misinterpret something, and we want to avoid doing that.
Having said that, are there actual red flags that you look for at the beginning of a relationship? Things that you look out for that make you realize, maybe this engagement isn't for me?
There are for me. Some attorneys want a specific opinion. Maybe it's important to their case and they need that opinion. In my work in analyzing photographs and video, I don't know what my opinion is going to be when I initially look at the case. I don't know what the evidence is going to show. And if they have a definite outcome that they want from me, that's a little bit of a red flag. Um, if they're overly aggressive, that's a bit of a red flag as well. If I feel like there is not an equal relationship, if they're overly demanding, overly pushy, then I feel like I'm going to regret taking an assignment from them later. So that would be another.
Professor Bikson, same question. Are there red flags that you look out for?
Again, those are, always excellent points. On the one hand, as an expert witness, in that kind of situation, we are hoping, right, that to be able to sell our services to them, right? And so we're trying to be as accommodating as possible. But as just described, I think it's really in our interest to be as honest and as straightforward with them about what we feel comfortable saying and what we don't feel comfortable saying. Usually in those initial interviews, it's not, you haven't even had a chance to review the facts yet. You know what I mean? They might have sent over some material, but it wouldn't make any sense to spend 10 hours reviewing something in anticipation of a 15-minute call about my qualifications. And so obviously when they start talking about these issues, you got to be very careful to say, I don't know, right? You sent me something. I certainly, I made a point of looking it over quickly because I wanted to be ready for this call, but I'm in no way ready to give you any sort of technical opinion on it. And I think that's quite appropriate.
Is that, an issue that you run into where you really aren't able to answer questions during that initial interview because you don't have all of the facts? Are there times when you take an engagement only to then receive the full amount of information, then realize, oh boy, I wish I hadn't taken this after all?
I mean, a lot of the cases I've worked on, there's a lot of materials, right? It could be hundreds of pages of materials. You might even be looking at depositions from other experts. It's a lot of material. So you haven't even seen anything in that initial interview. At most, they might have sent you one document, right, that you looked over briefly. So I'm not sure how to assess coming into a matter, whether I'm going to end up in a situation where I wished I hadn't taken it on. I mean, most of these types of matters, they do tend to be intellectually stimulating. They do tend to be compelling. There's things on the line. There's stakes on the line that make it exciting to be part of the process.
Mr. Reis, have you run into that situation where you've taken on an engagement only to find out that you wish you hadn't upon reviewing the information from the attorney?
I've had cases in which I wish I hadn't taken them on, maybe not exactly for that reason, but I could think of a few examples. And one example is the attorney that retained me was certain that he knew the reason why the video had some problems. And he was certain that it was somebody had manipulated it and edited the video. And through my analysis, I discovered that it hadn't. We met at opposing attorney's office in order to review some equipment that recorded the video originally and looked, and I was able to show him there that there wasn't intentional editing, and it was very concluding information that we got. And he wouldn't even talk to me on our way back out to our cars because he was determined that it was editing that was done. Later on, he kind of calmed down a little bit. But I should have seen when he originally called that he had a definite opinion as to this is what the case was. This is how this was done. This is this thing that I need to prove. And I've had other attorneys in the same way. They have something in mind. They know that's the case. They're incorrect in that knowledge, so they don't actually have that knowledge. And then they push you a little bit to try to come to their predetermined opinions, which is problematic. And if you could avoid those at the beginning, it's best.
Professor Bikson, have you had a similar experience where an attorney has maybe nudged you a little bit harder than you would prefer?
I appreciate that concern. I think obviously a lot of attorneys are going to be very careful not to do that. So one would hope.
Sure.
I think a lot of them recognize that you're going to be the most useful to them if you come at things objectively and you're really able to back up your conclusions. right? And to go on a limb in a direction you're not very comfortable with or that you can't support, may ultimately make you not a very good witness, right? And so I appreciate, everything George was saying, but also again, he recognizes, I recognize, I think many lawyers recognize that the best witness is someone who believes very strongly and has confidence in what they're talking about, and has not been pushed into a corner that ultimately they can't defend.
That's a good segue into bad news. How do you deliver bad news to the attorney? You come across something and you realize, wow, this is not going to go the way that they want. Now, obviously, expert witnesses' duty is to the neutral truth, the unabridged neutral truth, not to the end client. However, the attorney ostensibly is bringing on an expert witness because they believe that the expert witness's opinion is going to aid the end client. So when those two things butt heads or are at loggerheads, what is the best way to deliver that bad news to the attorney?
So I'm going to start by saying I'm not sure that I would call providing the truth about the analysis as being bad news. And one of the things that I consider a role of the expert to be is kind of like in the movies, not the hero of the movie, but the guide. So Yoda to Luke Skywalker. The attorney can be Luke Skywalker. I want to provide the attorney with the information that I have in my field in order to help them understand it so they know how it's going to work in their case. So if I find that the person in this video that's being accused of bank robbery is indeed their client, it's good for them to know that as soon as possible. So it may not be news that they want to hear, but it's news that's valuable to them just the same.
Professor Bikson, same question.
Yeah, and I think often it's not a simple, yes or no as far as the answers that they wanted to hear, right? You're trying to unpack the facts, you're trying to help them understand the evidence at play. And part of what the lawyers are doing is they're developing their own strategy, right? They're trying to figure out what arguments they can make and what arguments they should not make. And so what you're not necessarily, it's not necessarily good or bad news. You're trying to help them understand the facts and where those facts may lead, and that will help them, right, inform them what kind of strategies they should take. Okay, this is a direction we should go on. This is a winning argument. This particular argument is going to be very hard to support. And a lot of the situations that I've, had a chance to work on, there are many decision points, right, where the lawyers can, they choose the hill that they want to die on. And so, exactly to George's point, you're giving them the best possible information, so they come into it, equipped to pick their battles.
Let's talk about wrapping up an engagement. One of the things that I've had a lot of differing opinions on from different expert witnesses is how involved they remain after their portion of the action is done. In other words, you've given your deposition, perhaps your testimony if it's been a jury trial, and then you might be finished even though the case may proceed. It may proceed to settlement. It may proceed to go all the way through to a verdict. Do you contact the attorney afterwards to find out how it went? Do you maintain a relationship for networking purposes? And do you do things like jury polls or anything like that to see how you did, to get advice just vis-a-vis your own performance?
All right, George, you went first. I'll go first this time. It's always harder to go first, isn't it?
I was hoping you were going to go first.
Yeah. It's nice to hear the other opinion and be able to build up on it. I never even heard of the option of like somehow going and polling people independently. It has been my experience that once your contribution is done, the level of communication you get drops maybe to zero, which could be a big contrast. So up to that point, maybe you're speaking for hours on a daily basis leading up to this particular moment. And then once your contribution is done, I think it's natural that the lawyers who have a lot on their plate are transitioning their focus to things that they need to, be it, things in the case or maybe just getting back to their family. So I have not found in my experience that I get reports afterward about what necessarily the results will be, but I have found out that when I've emailed and I've asked, I'm curious after this whole process what the resolution was. They tend to be rather happy to sort of, share what information they can. And often that's interesting me to find out, right? It's educational for me to find out what was the final decision and what was the rationale for it. Of course, there are other situations where the matter is settled. So you spent a long time, developing whatever particular arguments you did, and you provided your technical support. But the issue gets settled, and at that point, it's hard to know specifically what role you played. Hopefully you played a positive role, right, in your side getting the best resolution they can.
Yeah, so we're actually in more agreement on this. This is good. This is an area I thought we might have had a little bit of disagreement or different views on. So I generally don't ask the attorneys what the resolution of the case was unless I have a reason to want to do that. So maybe my role in it was more complex than usual, so I'm curious about it. Or maybe it's a brand new client and I want to develop a long-term relationship with that client. So following up is nice, especially and as Marom said, the issue of when things are settled prior to going to court. One of the things that is good to know is in a follow-up email or a call and say, I hope that the information that I provided was valuable to the settlement of the case. And that just helps, I think, establish that long-term relationship. For jury polls, I've had a few cases in which attorneys have done jury polling. And in those cases, I haven't asked, they've just provided me information. And it's usually good to hear when there's opposing experts and to hear how jurors viewed each expert. And, especially if you're against somebody that you had concerns about in the first place for various reasons. And this can either confirm it or you can say, oh, I perceive that differently than what a juror would. So those have been very nice to get in the few times in which attorneys have provided me with that juror feedback.
Mr. Reis, do you believe that this is something that attorneys should be doing routinely, giving their experts, not just jury polls, but feedback in general? Because in my view, it seems that ultimately it would help them as well, because the better you are at your job, ultimately, the better you can do for their end client.
That's an interesting question. So for a new expert, absolutely. And I think every attorney knows when they're hiring someone that's a new expert, and giving them feedback, it's essential to help them grow and get better. With a seasoned expert, it's a mixed bag. Some seasoned experts obviously are good at their work. They hopefully know that they're good at their work and maybe don't really need that feedback. On the other hand, maybe we have bad self-perception. We think we're good and we have some areas we need to improve upon. And that would be valuable as well. So I'd say it's up to the attorney, but if the attorney thinks that feedback would be helpful to the expert, I'd always love to get it.
Professor Bikson, do you typically know the attorney when you get an engagement? In other words, are you being called by paralegals or other representatives, or do you typically speak one-on-one with the attorney during an engagement?
In my experience, almost always with the attorney, and it's often ends up being the attorney that I end up working with. A lot of the stuff I do is sort of an intellectual property. So these would be specialized lawyers, and maybe because they're very invested in their experts. So they're talking to me from the get-go.
Sure. Mr. Reis, same question. Do you typically speak first with the actual attorney for the case, or do you get a representative?
In at least 80% of the time, I talk directly to the attorney that's involved. Sometimes it's to an associate attorney who's working with a partner on the case, and that's fine. Once in a while, it is a legal secretary or a paralegal. In those particular cases, I haven't asked who is the attorney, because I think at that particular point, my initial conversation with this paralegal, let's just assume it's a paralegal, is going to be where I'm going to build that relationship. So I want to know, how that's going to work. And there might have been one or two times I've regretted not finding out a little information about the attorney in those cases.
That actually brings me to my next question. Without naming names, are there attorneys that you wouldn't work with again And a follow-up to that is, if they call you or a representative calls you, how do you handle declining those engagements?
One of the obviously, very disappointing or discouraging aspects of perhaps having being an expert witness is if the client is somehow hesitant or non-compliant with compensating you for your time based on the agreed terms. And I don't know, there's different reasons why they might be doing that, right? And so I think that is an point in a relationship. I think we're often asked to be extremely responsive. We need to do something over the weekend. We need to be available. And I think we as expert witnesses, we try to be good team members, and we do that. In a similar way, you don't want to be in a relationship where it takes months of follow up to have an invoice paid, or where you feel that that's not being followed up on. So I think I haven't had many of those situations, but in situations where that does happen, that certainly becomes usually the lawyers will suggest that it's the client rather than them. But in any case, that's a situation where there's a lot of frustration. And where if you were to go back into a relationship with that client or with those lawyers, you may ask for a retainer, and you may do other things in order to make sure that you're not backed up into that situation. Obviously, as long as the case is ongoing, you have a little bit of leverage because they need you to keep supporting them. But once the case is over, you're expecting them just to ask responsibly. And to clear out any remaining invoices and expenses.
Mr. Reis, attorneys that you would know that you would never work with again, without naming names, is this something that's happened?
Well, I have a list. Let me actually read those names. Yeah, there are definitely a handful of attorneys who I would not work for again, and in a couple of cases, they have called, and I just refer them to someone else. If it's to somebody who, when I refer them to someone else, I like to let that other person know, when I worked on a case with this attorney in the past, I had this particular issue. Want to make sure you're aware of that going in, and then they can deal with it how they wish.
Beyond billing problems, have there been other categories of issues that you've come against that would prevent you from wanting to work with a specific attorney again?
Well, and those would be the cases for me. I generally don't have billing issues, of course. So I'll just give one example. I had an attorney who wanted me to give a certain opinion, did not indicate that in the initial call. I had a call with him, letting him know verbally what my results were. He said, yes, I need a report on that. I said, great. I wrote a report, called me up and said, I can't use this report because you didn't say X. And I said, well, we had a phone call, and I explained to you what my findings were. You had no issue with it on the call. Now you're saying something else. And he said, well, let me send you a deposition that you can read, and then I'm sure that will change your opinion.
Oh, boy.
And it was a traffic accident, and the person didn't recall being in the accident or pressing on the brakes. And the issue was in the video, did the brake show or not? And so I called back the attorney. I said, you're right. I'm going to completely change my report. I'm going to write that there was no accident because the person didn't remember being in one. So he wasn't happy with me. I wasn't happy with him. End of relationship, except 2 weeks later, he sent me a LinkedIn request to connect on LinkedIn, which I just ignored. And, if he were to call, obviously I would refer him to somebody else.
Yeah, it's interesting. I try and usually keep the show fairly positive, but it is those negative experiences can sometimes be the learning experiences. Those are the things that newer expert witnesses need to hear so they know what to do when they find themselves in those sorts of situations. That said, I'd like to shift gears a little bit and talk a little bit more generally about the attorney-expert relationship. What in general, Mr. Reis, makes for a good expert-attorney relationship? What are the main factors that you look for and that the attorney should be looking for in making a positive engagement?
I think there's two things, at least two that come to mind. One that's great in any relationship, and that's good communication. And I think so many things can be resolved if communication is good. And then the second thing is being competent at your work, delivering more than you promise to deliver and never exceeding beyond your area of expertise. So knowing where your limits are as well as being competent in what you're doing.
Staying in your proverbial lane.
Those were, I think, the excellent points. I guess I would add that sometimes you may be working in a case and it's rather complicated, right? Again, you're dealing with hundreds of documents, many potential arguments, and so on, and um, uh, the lawyers may be asking you to answer a very specific question, but there's 1,000 directions you can go with it. And so sometimes a good relationship is where you start working on these problems and you're having discussions with the lawyers, and they identify areas that they think are a bit of dead ends. They identify areas that they are excited about because they think these things are legally actionable, and therefore you as an expert witness can sort of continue to focus in those directions. I think I've learned that those kind of iterative discussions are useful. They're not changing how you look at the facts. They're not going to change the conclusions you reach. But when there's so many documents at play and so many kind of ways you could approach the problem, right? Like let's say there's a IP case, and there's 10 patents, and each patent has 10 claims. You have 100 claims you could be looking at, depending on what the goals are. Where you place your attention is something that I think you can learn. The other thing is, as far as questions we asked the lawyer, you asked before about when the matter is done, but I do find that sometimes when the matter is ongoing, I do want them to explain to me the legal process a little bit, the kind of motions that they're going through. And again, it doesn't necessarily directly affect how you're going to look at the facts, but it gives you a little bit of a perspective, of what kind of arguments are being made, and what is the type of product that they're looking for you to deliver at each stage, right? They'll tell you, obviously, usually they'll say, this is the question we want you to answer. But I found that process has been educational to me. It's useful both just on that case, but also in future cases when you're working on similar matters and you understand now, okay, now this is this motion, and this is the question that I need to answer at this part in the case. Later on, I'm going to have to answer that question in a slightly different way. And so that, I think, is an educational process that carries through even to new cases.
That's an interesting point regarding strategy. How proactive should expert witnesses be in assisting their attorneys with strategy? If they think that it might be best to say X during the deposition, but say Y during the trial, for instance, or if there's a better way to communicate something, should the experts be proactive with their attorneys, or should they basically stand back and let the attorney steer the ship?
That's actually a great question and complex, because there's a lot of ways to look at this. And one of the things I would just say in the difference between the type of work Marom does and the type of work I do, he works complex patent cases. I work cases in which I'm clarifying video or determining whether or not a video or photograph has been altered. And so my cases are much, much simpler. But at the same time, strategy is essential in my cases that are less complex as well. One of the things that Marom is working with are attorneys that know his field well also. In my case, I deal with attorneys who don't know my field well. Knowing about video or knowing about authenticating photographs, something they might have in a handful of cases, so they're not going to be well versed in it. So knowing the strategy they want me to take in a deposition is always valuable. Do you prefer me to answer yes or no, or do you want me to go ahead and provide narratives, for example? So that's essential. Educating the attorneys in my case is valuable because they generally call it, I don't know anything about this, but, and then, so therefore they're looking for me to provide them with the information, with an understanding of the technology that's behind the evidence that we're looking at, and with an understanding of what questions they should ask in depositions and in trial. So from the standpoint of providing them with the information, it's essential, and understanding the strategies they want me to take during deposition and trial testimony is good.
That's an excellent point. Professor Bikson, when you are working with attorneys who, as Mr. Reis said, are ostensibly understand their field, are in the same field as you, aren't lay persons vis-a-vis the subject matter, do you find it makes them more or less receptive to your strategic suggestions during the case?
That's interesting. I like answering after George because I agree with what he said, and then it lets me, I can build on from there. Um, on IP matters, on technical matters, it is often the case that you're working with lawyers who have some domain technical expertise, like maybe they had an undergraduate degree in engineering, or maybe they have previously worked on similar matters, or one of the lawyers on the team is brought in to have that level of it. And so that is one aspect of it. But by its very nature, obviously, you're going to have a level of a depth of expertise that they don't, right? Which is, you would hope so, right?
Sure.
And so even when they come in and they have some technical background, there is a space with which they may not have the same kind of clarity that you do. And so I think it's very useful to sometimes say, okay, let's rather than just focus on exactly the facts of this case, right? The particular image or whatever particular claim that we're looking at, I want to take a little bit of time and I want to explain to you how this particular technical field works in very simplistic terms, in terms that might even translate to the way you would speak to a judge, right? Or to a jury. And I want to walk you through that and so that I can, and I think that they appreciate that. I think that empowers them to then understand how you're reaching your conclusions. So I did really like that point, and I also like the point that was raised around strategy. The way George broke it down, that there's an aspect of it of how they will advise you to present yourself, right? Just like qualitatively, whether you should be giving long answers or short answers in this particular situation, or what the expectations are of you. And so that's one level of strategy where they're kind of telling you what to do. The other level of strategy where sort of you're telling them how to approach things at a high level, I find that rarely happens in that sense, right? Where that's supposedly their job, right? And so
Sure.
they're deciding on what arguments to make and what motions to, and you're doing everything you can to provide them with facts and analysis to help them make that decision. As we're trained to say, right, on the expert witness stand, I'm not a lawyer, right? So
Sure. Absolutely. The way that you answer questions, as you stated, matters a lot, not just the content. Let's talk about demeanor a little bit in depositions in the courtroom and the preparation for demeanor that your attorneys give you. Professor Bikson, does your attorney typically give you advice on how to present yourself, how to answer questions, both not just the content, but kind of your mannerisms, even down to the way that you dress? Is this something that comes up, in terms of strategizing with your attorney?
There'll certainly be preparation, right? And how much preparation will depend on how confident they are, right, in your experience, right? Which is a judgment they will take, and also obviously the stakes of the case and where you are in it. So I have been in situations where over very extended periods of time, we've sort of gone through sort of a mock back and forth. In that context, they'll certainly pause and say, okay, in this case, I would prefer you go in this direction, or I might even say, I'm not, let's step outside of this role playing. I want to ask you a question. I don't really understand in this case what would be the expectation from me. I think those processes have been very educational, because I think the way you speak, the precision, that you need to speak with as an expert witness is not day-to-day communication. You need to be very
Sure.
careful in your choice of words. As George was saying before, to really stay in your lane and not get into areas that you are either not your domain of expertise or not things that you were asked to look at, and not to go in those directions. So those are all things that you do get from the lawyers. I mean, I think generally, as far as your demeanor, I think you want to be very even. I don't think anybody wants to see a hysterical expert witness, right? Or to lose your cool, even in situations where you may be very pressed. I also find it's very useful to kind of find your pace, which may vary from situation to situation and not change your pace. So if someone is coming at you very quickly, like I had a deposition where within the first second, just like out of the gate, right? Let's go. A very rapid fire question came to me. And I just took a breath, and I thought about it, and I made sure that I answered it when I was ready. So making sure that depending on the situation, you also keep a pace that you're comfortable with, and that you're able to really think through each one of your answers to make sure that you speak in the most accurate way. That's useful.
Mr. Reis, do you agree? Have you done mock examination or mock cross examinations or mock depositions to kind of prepare for these cases? And do you find the advice of your attorneys vis-a-vis demeanor to be useful?
Yes, in both cases. And now it's my turn to say, boy, I love coming after Marom because he makes great points that I agree with. And I can, instead of building upon it, maybe give a couple of examples of when that attorney prep has been very useful. So one example is I was in a federal case, and when I met with the attorneys prior to trial, they did not talk to me at all about the facts of the case or about my evidence, but instead about opposing counsel. And opposing counsel earlier in the case was actually exhibiting psychological problems. And the judge actually in that case recommended that he see a counselor. And so the prep on that case was, be aware this attorney might start yelling. They might go way off on completely different topics. And so be aware of that so that you can be ready for it and not react, but instead be ready to answer relevant questions. Another case was when I was testifying in London on a matter last year. The attorneys that prepped me in that case, and I was retained by, said in arbitrations in the UK, we generally have rapid fire questions. And that's probably not what you're used to in the US. And so they spent a day and a half with me asking me rapid fire questions so that I would be ready for that, which was very, very helpful because it would be a very different aspect. However, in that case, it turned out the attorney on opposing side that was questioning me was from Texas and was very laid back, and it didn't ask the rapid fire questions. But boy, I sure was prepared if he did.
Professor Bikson, given these preparation methods, do you feel that you typically have ample opportunity to properly prepare for a case before your portion, be it a deposition, trial, or what have you?
You certainly hope you have ample time, right? You know what's coming. Usually at that point, you have a very good understanding of what the issues in the case are. You have a good understanding of what you're going to be asked about. And you have a good understanding of what you're going to be challenged on, right? Because you sort of identified there's some sort of key wedge issues perhaps that are very important to either side to and they're going to want to push you on those on those issues that may be the really critical ones. So hopefully, you are prepared. It is a very unusual form of interaction, right? And it has this adversarial quality to it, right? And so, at least for me, obviously, there's a little bit of anxiety in the sense that you want to do well and you want to speak clearly and truthfully to the facts. There could also be a little bit of anxiety that we're not used to being in a situation where we may be being interrogated by someone who is trying to discredit you, right? Who's trying to show that you're inconsistent. And again, that just requires, first of all, starting from a position where you're speaking about things that you are confident in and which are true, right? And those, as the saying goes, if you what's the saying? Like, if you always tell the truth, you don't have to remember anything, right? Because it's only, with the lies that you get caught up. So, you're speaking from a position of confidence where you think the facts are on your side. And, I've been in situations where they will find quotes of things you've said in the past, right? That if they're taken out of context, appear to be the exact opposite of what you're saying now in a different context, right? And so they will challenge you. They'll say, okay, is A true? And you'll say, yes, A is true. And then they'll pull something up from a completely different context. And you say, well, did you say A is not true? And again, in those kind of situations, you want to, respond as clearly as possible to say, yeah, in that context, right? A was not true. And in this context, A is true. And so those are kind of the situations that I think especially the more experience I've had, the more comfortable I've been. And I think if you're not experienced in that kind of situation, you might be caught very off guard, especially if you're sort of come from more sort of technical, nerdy background. That's not how you're used to interacting with people. And all of a sudden, here's someone who is coming at you, with this sort of barrage of inquiry that is, again, intended to almost try to make you seem like trying to discredit you.
Mr. Reis, you're a published author. Have you had this happen to you, or where people will try and either take the things that you've said or written out of context, or try and impeach you on something that you said 40 years ago?
Surprisingly rarely. So yes, it has happened. I've had quotes from articles I've written. I wrote a book, which actually I don't think anybody ever read, because nobody's quoted that. And I actually in court one time got asked about my political views, which I found quite shocking. But I had run for state office once and was asked if I was the same George Reis. And then they started to ask, and do you hold the opinion that? And of course, obviously, retained attorney objected, and later on told me, it's great that the jurors saw that you take civic responsibility and run for office, but no matter what your view is that they were going to ask you about, half are not going to like it. So, but you just don't know sometimes what's going to be asked.
Absolutely. One of the things I'd like to ask about that I've had a few experts mention are the utility of visual aids in reports to juries and when have you. Have you used visual aids as an expert witness? And if so, have you found that it's useful in either explaining something difficult?
Well, that's an easy one for me, so I'll jump in. All of my evidence is visual. I analyze photographs and video. So in every single case, my reports are illustrated. And in my testimony, I always provide illustrative evidence. There actually was one time in which the judge did not allow me to publish to the jury my visual exhibits. And so in that case, I actually had to describe them verbally, which was a little bit awkward, but I think that it ended up working out. But with that one exception, yeah, I always have visual evidence.
Professor Bikson, visual aids?
I think for me, they come up more rarely, but I think probably for the same reason that George might use it, which is that, they're serving an explanatory process. And so you want to explain a concept. And the best way to explain that concept is to create a cartoon or some kind of block diagram that helps them see what you're talking about. Though again, in the situations I've worked in, it doesn't come up so often. I mentioned that example where sometimes I'll come up with a visual tool in order for the purpose of in my discussions with the lawyers. And in some cases, they will really like that, and they'll say, okay, we're not going to ask you to bring that into the report. But unless it's specifically asked for, at least in the kind of stuff that I would do, you don't generate sort of new imagery. Sometimes there may be a particular figure, which is very important or is being contested in some way, and you might annotate it. And so in those cases, I might add some marking. This arrow right here is what I'm referring to, but not more than that, typically.
These days, a lot of larger trials tend to have teams, and sometimes they can be quite large with a number of experts, several attorneys, and a host of staff helping with the case. Where does, Mr. Reis, where does the expert witness fit in overall in a trial team, and to what extent do they work with the other members of the trial team? Does one type of expert work with another type of expert, or does everything funnel through the attorney first?
Yeah, that's really depending upon the case. So I work many cases in which other experts are going to rely on the evidence that I provide. So they want to know certain things about the video in order to determine what the speed and impact was in an accident and what the damage was and what the injuries could be. So in that case, I'm working directly with the other experts in order to provide them with the information they need. But in most of my cases, I'm working directly with the attorney. Maybe my evidence doesn't affect other experts' work. But at a time, I've worked a couple of military cases. And in the military cases I've worked, the JAGs bring in all the entire team for the entire trial, where they're actually at opening arguments and where they're at sentencing. And those have proven to be, of course, interesting, because watching the other experts in different fields can be valuable, just from getting an idea of your disposition when testifying, the way to phrase things, how they answer questions. So it's educational from that standpoint, but also, surprisingly, pieces of information can come in completely unrelated experts' testimony that then becomes valuable to something that you were analyzing. So I found that when we can work with teams and interact with each other, there can be an added value to that could be unexpected.
Yeah, it's an interesting question. One thing I've done more and more on cases I've been working on is that I may bring in other experts to sort of work, let's say, with me or under me. So I would actually maybe be the main expert that this legal team is referring to, but I'm telling them, look, there's some dimensions here, and you're going to want to bring in other people. And so again, in that case, I'm going to be working directly with the lawyers, but hand in hand with these other experts that I may have been recruited. My experience has been, at least, that when there's other experts on the same side, right, that I'm working on, often my interaction with them is very compartmentalized. I think sometimes, at least, my experience has been that the lawyers are actually very sensitive to the nature of that communication, because it has it's not just casual discussion.
Sure.
So in that case, they control that communication. You know what I mean? And usually when you have those interactions, there's a specific goal in mind. They want you to exchange information on a particular topic, and they would like to leave it at that. You know what I mean? And so, for example, that expert is writing a report, and that report relies on something that I need to opinion on. And so I'm speaking to them to convey that information to them so they can move on ahead. There's an engineer who works in a company, and they're speaking to me to relay to me very specific information that I need about a particular product that is critical for me to write the report. And again, the discussion is limited to that sense. Another interesting thing it made me think about when you asked that question is, I've had a lot of differences in the size of the number of and representatives of the legal team that I'm working with, where I've had cases, and in some cases are very large, and I will only talk to one lawyer. There won't even be anybody else on the call. But it's very it's one. I know there's other people around, but the way they could compartmentalize it is that the entire time, this went on for months, I only ever spoke to one person, and that's how I was conveying all. And the emails were only. And then there's other situations where there's multiple people involved, or where depending on the matter, I'm being moved from one person to another. And so it's very interesting to me that different law firms have different cultures about how they approach the way the expert is who the expert is communicating with.
Do you have a stylistic preference there?
No, not at all. But it's very different, I would say. It's quite, when you're dealing, it's a different thing when something will have, you'll have four lawyers on the call with you, five lawyers, they're all there, versus just one, knowing that person is then communicating that information to the other ones. I guess that it must be a strategic decision of how they want to go about doing things. And so, no, I wouldn't. For me, I don't think it necessarily affects things one way or the other. It's, I mean, I guess you develop a closer relationship when you're just talking to one person, and maybe that's part of it, right? That it's always you and that person. It's not you and four others.
Before we wrap up, I'd like to ask each of you for any last advice that you have for expert witnesses, and in particular, newer expert witnesses. This time you get to go first, Professor Bikson.
I think especially if you're new, regardless how strong you are technically, you're not going to have the same experience as far as writing reports, as far as depositions, and that is something that they're going to be sensitive to. And so I think we talked about your communication and your demeanor, right? That was something that George was emphasizing, that communication aspect of it. That's really going to be very important. that you pay very, very close attention to your ability to project and be very clear in your discussions with the lawyers, because they will be assessing that. So that is something, I think it always matters, but perhaps that has extra weight when you have less experience to lean on as far as records of, again, writing reports or being deposed.
Last advice, Mr. Reis?
Two things come to mind. One is meet other experts and form relationships, so in that way you could get an idea of how they approach report writing, how they approach communications with attorneys, how they testify. And then secondly, I would say go to courtrooms and watch experts testify. That's incredibly valuable. I've done that. I've come to a local courthouse and just walked in on trials for the purpose of seeing what kind of questions get asked and how the experts respond to those questions.
Sage advice from both of you. Professor Bikson, Mr. Reis, thank you so much for joining me for today's panel.
Pleasure.
Yeah, it was a lot of fun. Thanks.
And thank you, as always, to our listeners for joining us for another discussion at the Roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.